Good afternoon, all. Sir will be joining in another 5 minutes, so we'll just wait till he joins. Can anyone confirm if I'm audible?
Yes, sir, you are audible.
Yes, yes. Thank you, sir. Hello, Chetan, sir. We could begin. Hello. Hello. Hello, Chetan, sir. Are you there?
Yes, you can start.
Okay, sir. Okay. So, good afternoon, all, and welcome to the pre-incubation session 7. So, I would like to begin with a short intro with about CS Chetan Naik, sir. So he is a professional with over 5 years of experience in corporate compliance as a practicing company secretary and registered valuer in securities and financial assets. Sir excels in secretarial and RBI compliance, company incorporation, and organizational setup, specializing as a startup consultant and serving as an expert advisor for farmer producer companies. He brings a wealth of experience. His expertise spans the preparation of income tax returns, uh, Excel audit reports, financial statement assessments, and adept handling of legal issues for various entities. Additionally, he is skilled in preparing trust accounts. His value extends beyond technical proficiency. He has a proven track record of identifying and implementing strategies that enhance sales, strengthen customer relationships, and drive overall growth. His ability to build strong relationships with organizations and with external parties, including partners and consultants, underscores his professional acumen. So he is not just a practitioner, he is a strategic advisor poised to contribute significantly to corporate compliance, valuations, and business growth. So I welcome you, sir, and thank you for this, uh, being a speaker for this session. Over to you. You can continue, sir.
Thank you very much,
Yes,
Sodhan, for a wonderful introduction. So welcome all the participants. I will be covering the basic compliances under the Companies Act. Since the other compliances are slightly complicated and generally the persons who are not involved in day-to-day compliances, for them it will be very difficult to understand. So you always need a help of the professional to take care of these compliances. So all the participants can post question anytime in between the seminar. So I'll be sharing the screen now. Hope everyone can see the
Yes,
screen.
sir. It is visible.
So this is the basic compliances under Companies Act. Generally, when we do the due diligence prior to the funding, we find a lot of discrepancies and mistakes. Even though there are consultants who are handling your company. So if you have this basic knowledge, even when your consultants, whether your CA or your company secretary, are making certain mistakes, you can identify those mistakes also. Some of them you yourself can continue to do it without the help of the consultant. Other compliances under this Companies Act, it is quite complicated and always you require the help of the consultant. So the first one is the post incorporation compliances. So once the company is incorporated, what are the compliances you need to take care of? So even in these compliances, we find a lot of mistakes when we receive the documents for due diligence. First thing is you need to hold the board meeting within 30 days of incorporation. So the document to be maintained for the board meeting, this is not only for the first board meeting, you have to maintain these documents for all the board meetings. So documents would be the attendance sheet, notice of the meeting, and minutes of the meeting. So the notice period for holding the board meeting should be sent 7 days prior to the date of the meeting, minimum of 7 days. So either it can be sent physically hand delivered or through mail. Nowadays, everyone opts mail for sending a notice for the board meeting. So there should be a minimum of 7 days notice period. So you can also hold the meeting in a shorter notice also. So in case of shorter notice, you have to mention in the notice saying that this meeting is being held at the shorter notice. And there are few list of documents, the list of points which you need to be aware of at the time of holding the first board meetings. So for example, I'll just share another screen. So this is a draft of the notice. So this is how it will be. It will be, hello, can you see the notice?
Yes, sir. Yes, sir.
Yeah. So this is the draft of the notice where you will give the description of the date, time, and place where the meeting is being held. And these are the general points at the first board meeting. Almost all the companies will have these points. For example, chairman of the meeting. So you have to elect the chairman at every board meeting. So the quorum of the meeting. Quorum is one third of the total board of directors, number of board of directors, or two, whichever is higher. For example, if there is 2 directors, minimum 2 directors are required to attend the meeting for holding board meeting. In case of 5 directors, minimum 2 director has to be present. And in case of 9 directors, minimum 3 has to be present. Otherwise, the quorum it will not form a quorum and you will not be able to hold the board meeting. So grant of leave of absence. The leave of absence will be granted to the people who have not attended the meeting, but they have already informed that they will not be able to attend the meeting. So mode of attendance. So mode of attendance, whether it will be a physical or it will be electronic, that you need to mention you have to record it in your minutes. Minutes is the document where you will record the items discussed in the meeting. That draft minutes also I will be showing you. And you have to appraise the board on the incorporation of the company, saying that the company has been incorporated. Henceforth, we can start our business. And this is the incorporation certificate. You can place it in the board meeting. Constitution of the board. The board of directors is already appointed at the time of incorporation, but just confirming in the board saying that these are the directors which have been appointed. And memorandum of articles of association of your company is taken on record. Registered office of the company, and registered office of the company is also taken on record saying that this is the registered office. Maintaining the minutes of the board of directors in loose leaf. All the minutes, whether it is board meeting or annual general meeting or extraordinary general, all these terms, whatever I'm telling right now, I will give you a detailed description of what is annual general meeting, what is extraordinary general meeting, and other committee meetings also. So whatever the meeting is held, you have to maintain the minutes. Minutes in the sense, whatever you have discussed in the meeting, whatever the point you have discussed in the meeting, that has to be recorded in a paper. So maintaining the minutes of the board of directors. Authority for signing e-forms. There are several e-forms in ROC compliances which you need to file regularly. So you will authorize the directors to sign those forms while submitting the forms online. Financial year of the company. So the financial year will be generally from 1st April to March. The same thing will be confirmed over here. Take on record of MBP1 and take on record of declaration under section 164. This MBP1 declaration needs to be given by all the directors at the time of incorporation in the first board meeting, as well as at the first board meeting of each financial year.
Sir, what is MBP?
MBP1 is there is a format. This is a form which is available under Companies Act. So in this form, you have to disclose your interest in other entities.
Okay.
Saying that in these companies or in these trust or in these partnership firm, I am a director, trustee, or a partner. And what is the percentage of shareholding held by me? Generally,
this is for conflict of interest, is it? Conflict of interest.
Yeah. Just to show the conflict of interest. So the MBP1 and this one, declaration under section 164, that is DIR 8, is almost the same. But MBP1 is given to the company. Declaration under 164, that is also given to the company, but that document will be shared to the auditor at the time of auditing.
Okay.
So if I can say why this interest disclosure is shown, one is with respect to conflict of interest. Second is to identify the related party transactions. So if any of the director is director of another company, if company A's director is also a director in company B, any transaction between A and B has to be in arm's length price, means at a market level rate. So any deviation in those rate will create a problem, saying that you may have done it to avoid the tax or some illegal transaction or transfer pricing. So that is the reason this declaration of interest is given. At the end of the year, auditor will note all these transactions and they will find out whether these transactions what have been done with the interested entities, have those been done at par market rate, or is there any partial deviation. So that this is very important. So next one is preliminary expenses. Preliminary expenses are the expenses which you incur at the time of incorporation of company. So that will be taken as a preliminary expenses. Just noting it down in the meeting saying that this is the amount which we have spent at the time of incorporation and this will be considered as a preliminary expenses. And maintenance of statutory register, even this is important. So the detailed statutory register, how it is maintained, all those details I will share you later. Place of keeping of books of accounts. So books of accounts and all the legal documents or documents related to company are always kept in the and must be kept in the registered office of the company as per law. So any other place you are maintaining, that the same address has to be updated in ROC, saying that our account maintaining document maintaining office is different. So there is a return called as AOC 5 that needs to be filed. For I don't think so for the startup all these things will come. Generally all these things will come to the major companies where they don't have enough space in their office to keep the documents. They will shift it to different office and that will be notified to the ROC. Authorization to comply with company law requirements. Just giving an authorization to any of the director, saying that the company will be following all the rules and regulations and the conditions prescribed under the Companies Act. And
so is this applicable to us, sir? Startup as a company, are we required to comply with all these company laws?
See, for the startup companies, these companies are also considered as a small company. So there are certain exemptions. Those exemptions also I am going to come up. I'll show you what are the exemptions given for the small companies. But majorly, most of the compliances you need to take care. See, the reason why these compliances are there is not to hinder the business of the company. It is just to protect their own business. Because all these compliances are actually going to help you in the long run. So that is why these compliances are there. This is a company is a structured entity. So all these compliances are in a structured way. In future, like these compliances are going to reduce further, but it will take some time.
Thank you, sir. Thank
you. Yeah. Authorization for execution of contracts. So if you have to execute any contract in the future or any agreement, you are authorizing the directors now itself so that a resolution of the company is ready at the time of execution, or else the new resolution has to be passed. Sometimes what happens in the case of day-to-day business company, for example, where there is a live board meeting, there the board meeting has to be conducted to pass a resolution. So it will be very difficult to pass the resolution because the time schedule may not have been fixed. So if you have passed this resolution at the initial stage itself, later on you can use this resolution for executing certain normal agreements. So appointment of first statutory auditor. The statutory auditor has to be appointed within 30 days of incorporation. So in case if the company fails to appoint the auditor within 30 days, the shareholders can hold the extraordinary general meeting and appoint the auditor. So these situations will not come, but just giving a brief on what are the procedures. So auditor has to be appointed within 30 days of incorporation. So the form which has to be filed is ADT 1. So this form at the time of appointment of first auditor is not mandatory, but some of the companies, they generally file it and some of them won't file it. It doesn't create any problem if you don't file for the appointment of first auditor, but the reappointment at the time of annual general meeting, at that point of time you have to file ADT 1, where you appoint the auditor for the term of 5 years. So even if you don't file any return with ROC in the form of ADT 1 for appointment of statutory auditor, but basic documents you have to keep it ready. For example, the proposal letter, the confirmation letter, the board resolution. In the board resolution is same, the extract of the resolution saying that this auditor has been appointed. And proposal letter is where you send a proposal to the auditor that can we consider you to be appointed as an auditor. The board is considering you, so give me your consent. So auditor will issue a consent letter. So once the consent letter is issued, the board will take up those things in the board meeting, approve the appointment, and the confirmation letter is sent to the auditor saying that we are happy to inform you that you have been appointed in the board meeting held on this day. So the same documents will be there at the AGM also. So you'll send the proposal letter, the auditor will send the consent letter, and in the annual general meeting, the shareholders will pass a resolution for the appointment for 5 years, and the board will send the confirmation letter. All these documents you have to use it to file ADT1. So if you want some example, I can share you some other company example. So hope everyone can see this form ADT1.
Yes.
So this is the form which is filed. So this is the appointment of auditor at annual general meeting. This is not the first auditor's appointment. So the proposal letter this is the proposal letter which you sent to the auditor saying that we are considering your appointment at the annual general meeting. Okay. So after that, the auditor will send his consent saying that yes, we are okay to be appointed. We are okay to be appointed. We give our consent. So at the AGM, this resolution is passed saying that this is a certified copy of the resolution. In the sense, in the whole meeting, whatever you have discussed, that will be recorded as a minutes in the meeting. And one part of the minutes, one resolution, you have taken it outside and you are certifying it and giving it separately is called as extract of that meeting's minutes. So that is why it is written extract of the resolution of annual general meeting. So appointment of statutory auditor, this resolution, and later you will send a confirmation letter.
What is the difference between the?
Yes. Hello. Hello.
Yes, Dr. Ram, you can ask your question. I think you're on mute.
Hello.
Yes, sir.
Yes,
Tell me.
yes.
I'm sorry to interrupt you, sir. So
No
what is
problem.
the difference between minutes of meeting and the extract?
Yeah. See, minutes of meeting is in the minutes of meeting you record detailed things from the start of the meeting till the end of the meeting. For example, details of directors present, appointment of chairman, all those things will be recorded. Extract of the minutes is you take one part out of that minutes and you sign it and issue it to give it to someone. That is called as extract of the resolution. For example, here you have taken one part of the resolution.
Okay.
Not the whole minutes. Okay.
In what condition it is required, sir, like this?
See what happens at the time of opening a bank account. They will tell you to give the board resolution. So
Okay.
at that point of time, you will give this board resolution. Actually, it is passed in the meeting. Meeting will contain
Correct.
lot many things, but you are giving them one part of it. That is why it is called as extract. Hello.
Document
Hello.
based on the minutes of meeting, but it is a separate document, isn't it?
Yeah, you general normal paper you will sign and give it. This is
Okay.
one part of the things which you have discussed in that meeting.
Got it,
Not
sir. Thank you.
everything.
Thank you.
Because
Thank
you are appointing an auditor here. So unnecessary things which is not at all related to the appointment, you need not share to others.
Correct.
For
Correct.
example,
Correct.
when you're sharing a board resolution, you don't need not share whole minutes to the bank.
Yeah, it can include company strategy. So many things may be there in that.
Yeah, that is it.
Got it, sir. Thank you, sir. Thank you.
Yeah, thanks. So then the confirmation letter. So the confirmation letter will look like this, saying that we are pleased to inform that you have been appointed as a statutory auditor for a term of 5 years. So please note that you have to appoint the statutory auditor within 30 days of the incorporation. And once his term expires, his term will expire in the first annual general meeting. At that point of time, you can reappoint the same auditor, or you can appoint the new auditor for a period of 5 years. And if you are going for Udyamada registration and startup registration and seed funding application, you can pass the resolution at the beginning itself. And any other matter with the permission of the chair. For example, you send this notice to all the directors to attend the meeting. At the meeting, any one of the members of the board, like director, can say, I have one additional matter to be discussed. So that person can propose that topic, and chairman, if he is satisfied, he can allow that discussion to happen. So this is it. And here you will be mentioned, if you will mention that director interested in participating in the meeting through video conference can avail such facilities in this regard. Directors will have to send the request to this email ID and this mobile number at least 48 hours prior to the meeting. So this option should be given to all the directors. So any directors who would like to attend the meeting, but they can not physically be present, so they can send the proposal to the company saying that please arrange the facility for holding the meeting at video conference. I will join through video conference facility. So this is all about the minutes of the meeting. One of the point here at the first meeting will not come is that confirmation of the previous meeting. That will come after mode of attendance. So the confirmation of the previous meeting is the next previous board meeting, whatever you have held, that board meeting will be minutes will be confirmed in this meeting, and it will be signed by the chairman. So everyone is clear about this. If anyone have any clarification or any doubt, they can ask.
So this online meeting, how do you document it, sir? If there is a voting or if there is a minutes are raised by the online member, how do you capture it? You have to sign it, right? Generally, MOM, they sign.
No, see, once the meeting is held, you have to record it in the minutes, and that minutes after the confirmation from the chairman will be signed in the next board meeting. But one more thing in the video conference meeting is, the condition for holding video conference meeting is you have to record the meeting. It is mandatory. And it should be there in company's database always. So the recording of minutes is mandatory. If your recording of meeting is video recording of the meeting is mandatory if you are holding the meeting through video conference.
Oh.
Okay.
Even otherwise, audio recording is also permissible, is it?
Audio recording, it should have both facilities, audio recording and video recording both.
Okay. Thank you, sir. Go ahead.
And see, all these compliances are mandatory, but no one will come and check these things, whether these things are available, whether the company is maintaining these things, but it is mandatory. So what happens sometimes, suddenly ROC will come to know through someone else. For example, there might be some dispute in your company. So someone from your company will go and complain the ROC saying that they are not done all these things. That point of time, ROC will ask, give me these things, let me check whether you have maintained. They will send a notice to you. That point of time, they will check. Until and unless someone gives a complaint, no one is going to check. most of the company will not hold the board meeting also. But as far as present situation is concerned, I always suggest that at least to the minimum extent possible, you have to hold the board meeting. Sorry, even if you don't hold the board meeting, at least you have to maintain those records that you have held it. Because we never know at what time certain dispute will arise, who will go and give the complaint against you, your company. So at that point of time, these things will come, and I will also share you one link where you can find the ROC of all the states. They have imposed the penalty for all these things, where they have not held the board meeting, where they have not recorded the online meetings, where the proper documents are not, where there is no numbering of the minutes. For all simple things also, they have imposed the penalty. It doesn't mean that they will come and check your documents, but only thing is there is a possibility. That's it. Anytime it may be, there might be a possibility.
Sir, one more doubt. You mentioned loose sheet document something. Why it is specifically given as loose sheet minutes or something I saw in that page. I didn't want to interrupt you that time.
Yeah, previously, what used to happen around 20 years back, they used to have a book, and in the book they used to write it in pen. They used to record the meeting in by handwritten.
Yes.
But
yes.
nowadays there is a separate loose sheet which is available in stationery, which is specifically for recording the minutes. What you have to do is you have to just prepare the minutes, print it, and keep it. And after 4 or 5 years, when the minutes book becomes the sheets become very thick, you can bind it also, and it has to be binded also. Yeah. That also is as per law itself.
So because previously it is must be a note. That's all. That's not a mandatory now, is it?
No, minutes are mandatory. You have to. No, you have to record. It means they used to write it in a pen. Now it is not like that. Now you have to prepare it in a computer, take a printout.
Okay. No. My question is bound note is not compulsory.
Bound note also is possible, but this is very simple and easy. Sometimes what happens, there will be some correction in the minutes, no? So how will you do it in the bound one? You have to tear the paper.
Correct.
So here they will maintain it. After there is some binder lock also, which you will get in stationery. The popular stationery is called as industrial and commercial print, where all the company related documents and other things are available. For example, share certificate and other things. They also sell this board meeting minutes recording sheets also. So generally we take the printout in that, and there is one temporary binder also. We keep putting that sheets in the temporary binder and lock it. There is a locking system also. Once it reaches a certain limit, you remove that from that binder and you go and permanently bind it like a book. Hello.
Yes, I got it, sir. Got it.
So once that binding is completed, later on you can print fresh further future meetings minutes, and that also when it reaches a certain extent, you can bind it again. So the book becomes second book.
Most of the time our startup will be one-man company or maximum 2.
Yeah.
Startups, no?
Yeah.
Bootstrap.
So in your case and all, see, if it is a startup company and all, it will take several years for it to form as a book. So you can just take the printout, maintain minutes, take the printout and put it in one normal file using the sheet protector.
Okay.
Later on in the future, whenever the requirement comes, you can bind it.
Okay.
Yeah.
Go ahead, sir. Go ahead, sir. Thank you.
Thanks. So next one is filing commencement of business. Okay. So this is filed in the form called as Form 20A. So the time limit for filing this form is Form 20A is 180 days from the date of incorporation. So what are the things you need to attach in this form is, in the MOA, at the time of incorporation, in the subscription sheet, you'll mention these are the people who are subscribing to the initial subscription of the shares of the company. For example, person A and person B says that we subscribe 5,000 shares of rupees 10 each, total 10,000 shares of rupees 10, that becomes 1 lakh. So company has to open the bank account once the company is incorporated, and these money has to be deposited by A and B to company's account. And that bank statement with the geotagged photos. So this is one bank statement. Keep this point in your mind. That is the bank statement where the subscription money of the shareholders who have subscribed to MOA. If you go to your MOA, on the last page it is mentioned who are the subscribers to these shareholders, this company, initial subscribers. So those people, whatever amount they have mentioned to the shares which they are subscribing, that has to be transferred to the company's bank account. And the same person has to transfer. No other person can transfer on behalf of him. Same person has to transfer from his own account, has to be transferred to company's account. And the exact amount has to be transferred. Not your 1 rupee up, not your 1 rupee less. That bank statement has to be obtained from the bank. And second thing is, you have to take 3 photos. And those photos has to be tagged with the geotag information. So you will find several apps in your mobile for geotagged photos. So you can download that photo app, and you can take these 3 photos using that app. So that photo will contain the location of your photo also, from where you are taking the photo. So there should be 3 photos. Building photo, where your office is situated. These nowadays startups start from their home itself. So you can take the photo of your house. And office entry photo with the name board. So entrance of the office, near the door, you can put a board. One director should stand beside the board, and that photo has to be taken. So the board should contain company name, SIN number, PAN, company address, and local language translation of the company name. So third photo is inside the office, where director sitting in a chair with the table, and the same director should be present. Not where the entry photo is taken, the same director has to be present here also, not the another director. And the same person's digital signature has to be used to file the Form 20A, not other director's digital signature. The same person who is there in the photo, his DSC only has to be affixed. So these are the 3 photos which has to be taken. We have, at the time of due diligence, we have seen several commencement of business which is filed, where the amount is not matching. Someone else has transferred on behalf of the other shareholder. It is completely wrong. This filing of commencement of business is very, very strict. One or the other day, the ROC will come back and they will levy the penalty. That is for sure. They may not levy now, maybe 1 or 2 years they may not levy, but in future 100% they are going to come and they are going to send you a notice. So make sure that these documents are filed properly. That is the amount deposited in the bank statement and these photos. And certain people, what they do, they take the photo where there is no board, company's board in the entrance. They edit in the photo itself, and that is clearly visible that it has been edited. That is also actually wrong. You can just take the printout in the A4 sheet, just use sellotape and put that tape in the board and just take the clear photo. And the same person's digital signature has to be affixed. So,
Sir, one doubt. This building, any specification is there, sir? It should be pakka, it should be concrete, it should be
like
commercial.
No, nothing like that, sir. Nowadays, startups all starts from their home only. So commercial, all those things are not mandatory. At least for Companies Act, it is not mandatory.
A rented building also is enough, right?
Rented building also okay, your house is also okay. But
Okay, sir.
that address should be the exact address where you have incorporated the company. Which address you have given for the incorporation, not any other address. Exact same address only photo you have to take.
Okay.
And this filing due date of 180 days for filing Form 20A has some twist. I will explain you that in the coming up slides. See, other one is in issue of share certificate. See, transfer of share certificate is governed by Central Act, but issue of share certificate is governed by State Act. So issue of share certificate, stamp duty has to be paid. Every state, there is a different stamp duty. So whichever state your company is situated, just check the state's company's stamp act and see what is the stamp duty levied for issue of share certificate. So that stamp duty you have to pay. So you have to take the acknowledgement or stamp paper or e-stamp, whatever it is, whichever is available in that state, maybe franking also. And the share certificate has to be issued. And the share certificate should be issued in the format mentioned as SH1. That is actually as per Companies Act. I'll show you how that format looks. So this is the share certificate. This is a blank share certificate where we have not printed anything. Generally, the company name, its address, and SIN number, corporate identification number will come over here and here. And face value of the shares, if it is 10 rupees per share, it is mentioned over here. And registered folio number is mentioned over here. Certificate number is mentioned over here. Name of the person to whom the share certificate is mentioned here. Number of shares held is mentioned here. The number of shares, whatever you are being, and the distinctive number is mentioned here. And the date of issue is mentioned over here. And 2 directors has to sign, and any authorized signatory has to sign over here. If the company has only 2 directors, then third person can be some employee or the person, some officer in your office who can sign the authorized signatory. The same things are replicated here also. And here additional things are occupation and address and father's name. So distinctive number. Hope everyone knows what is registered folio number, certificate number, and distinctive number.
No, sir. No.
Okay. Folio number is a number which is given to the shareholder and it is permanent. It is never going to change. For example, you go to a doctor, physician, they will maintain your file and they will give you a number. So that number is permanent for you. It is not going to change. So at the time of issue of share certificate, one number is given. So that number is permanent. In future, additional shares are given. The folio number will not change. The folio number will be exactly the same. For example, if they, at the time of incorporation, subscriber to memorandum is A and B. So A subscribed 5,000 shares and B subscribed 5,000 shares. So as A's name is reflecting first, so his folio number will be 1. B's folio number will be 2. So you are clear that folio number about the folio number, or you are still having confusion? Okay, I hope that everyone understood. So certificate number.
So now who is issuing, sir, this one? You said it's a state government, right?
No, sir. This is issued by the company. Company is giving the shares, no?
But you told just now that one is given by state, another is given by
The stamp
central.
duty, the stamp duty which you have to pay.
Okay.
So you are transferring the property. Where you have to pay the stamp duty?
Okay. Stamp duty. Okay.
Everything has a stamp duty, no?
Correct.
Transferring the property, registering certain document, registering the house property. Any agreement you are registering, you have to pay some stamp duty, no?
In this state government, in this case, is it?
Yeah.
Issue of
State government is the authority for issuing the stamp paper. Maybe that stamp duty may be imposed by central government also. But the issuing authority is state government. For example, issue of share certificate, as I told you, the stamp duty goes to state government. Okay. But transfer of shares, the stamp duty goes to central government. But in both the cases, issuing authority for the stamp is state government only. But the amount for the transfer will go to central government. That state is going to deposit.
Okay.
Okay. So the registered folio is already same, like how we are having a file number for individual. So in additional, from this company, only from this company, I'm not telling about other company, from the particular company, any number of shares it is issued in the future at a different time, your folio number will always remain same, but certificate number always changes. So every new share certificate issued, the company will have a new number. In this case, A and B will have 1 and 2 share certificate number as a folio number itself. In future, again, 5,000 shares are issued to each A and B. The folio number remains same, 1 and 2. But the certificate number for the new share certificate will be 3 and 4. Okay. So you are clear with this? Hello?
Yes, sir. But those numbers are not given here, isn't it, sir?
So you want any?
3 and 4.
No, I am giving you an illustration.
Okay. Anyway, you will take handhold us when we do it, right?
Show it to you in next. Yeah, see, I will show it to you in Excel form. See, there is a person A, there is person B. So the folio number is 1 and 2. This is not going to change in any time in the future. This is like a file number for you. So next is certificate number. That will be fresh share certificate you are issuing at the time of incorporation, 1 and 2. 1 share certificate, 2 share certificate number. And shares issued is as per the MOA where you have subscribed 5,000 and 5,000 shares. Okay, this much is clear. So in future, you are raising the capital, you are issuing additional shares to same people. In maybe I'll take it as a different proportion. A and B will issue, and you will issue 3,000 shares to A and 7,000 shares to B. So here folio number remains same, 1 and 2 as their file number is. So here fresh share certificate you are issuing. So it will be 3 and 4. Okay. Hope this is clear. If you have doubt, let me know. So next one is distinctive number. So here, what will happen is, it is like a serial number. So distinctive number will be here. There is 5,000 shares. So 1 to 5,000 will be the distinctive number for the first share certificate. So the share certificate 2 will have 5,001 to 10,000. This is like a serial number. So this one will have 10. Can anyone say what will be the distinctive number for this part?
10,001 to 13,000.
Yeah, 10,001 to 13,000. So 13,001 to 20,000. So this will be the distinctive number, which is mentioned here in the share certificate in this place. So here also it will be mentioned in this place, distinctive number. So in further, I will show you where the folio number will come, where the distinctive number will come. All those things I will show you where exactly how it reflect in which place. So I will give you another illustration. This was not part of the presentation, but still I will give you. A new person is coming with the name C. So he is going to invest certain money, and for that investment, you are planning to give him 1,500 shares. Okay. So B will say that I am going to transfer shares from my holding to C of the total holding what I have. So B is having total of 7,000 plus 5,000, that is 12,000 shares. So out of 12,000, B is telling that I will transfer 1,500 shares to C for his investment at whatever price, whichever he is investing. So what will happen here? So whatever B share is having, that he is having 5,000 shares and 7,000 shares, each share certificate will have that. So how to transfer 1,500? You cannot tear the share certificate, right? So what you will do? You will split the share certificate. So fresh shares are issued in B's name itself. So B and B. So here they will split this share certificate into two parts. One is 1,500, another is 3,500. So what will be the whole number? Can anyone say here? Participants are requested to reply like
2, sir.
yeah, 2, correct. So can anyone say what will be the certificate numbers here?
Five, 6.
Yes, correct. So 5, 6. So that is how. So the share certificate, whenever you issue new share certificates, the new number will come. So the each share certificate will have a different share certificate number as a serial number whenever you issue a new share certificate. So the distinct number, can anyone say the distinct number over here?
$21,000. I don't know.
No. Here what will happen is, so here
0 to
this
1,000.
no. So
What?
this is the share certificate which is getting splitted. So here the distinct number will be 5,001 to 6,500 and 6,501 to 10,000. So you can see the start and end. You can see here and here. So this distinct number for a particular share certificate is fixed from this to this. So when you split, the distinct number will come like this. So at the time of transfer, you will transfer this share certificate, this one, 1,500 you're planning to transfer. So you will execute a share transfer deed, which is in the form of SH4, and you transfer it to C. The share certificate will be in the name of B itself. So at the transfer, what you have to do is, you have to mention the details of transfer here. The date of transfer should be mentioned over here. The transfer number, first time you are transferring in a company, so the transfer number will be 1. Folio number of the transferee. So the transferee is C. So what will be the folio number for C? Can anyone say?
3.
Yes, correct. So folio number of transferee, then transferee's name, initial of the transferor who is transferring the shares, that is B, and the authorized signatory is signed by the company, and they will affix the seal also that they have approved the transfer. So in case of private company, it is mandatory to have a board resolution for the approval of the transfer. Unlike public company, in public company, anyone can transfer the shares any time. No board resolution or board's approval is mandatory. But in private company, it is mandatory that the board has to approve the transfer. So you execute on January 20th, 2024, the share transfer between two people, A and B and C, and you submit it to the board of the company. The board meeting will hold meeting on 23rd January, and they will approve the transfer. So the effective transfer date is not on 20th. It is on 23 when the board has approved, but the document signing date will be on 20th. So it is mandatory that the board has to approve the transfer in the case of private company. So here the point to be noted is at the time of incorporation, once the company is incorporated, within 60 days you have to issue the share certificate to the shareholders who have subscribed to the memorandum of association. Okay, so as I told you, here there is certain twist for 180 days. Okay, they said within 180 days Form 20A can be filed, but the fund deposit, what you have to do, the subscription amount to the company's bank account, that has to be deposited within 60 days so that the share certificate can be issued within 60 days. So the amount deposit you should not take 180 days. You have to deposit within 60 days so that the company can hold a board meeting and issue the share certificate within 60 days. As I told you, next point is appointment of statutory auditor. Statutory auditor has to be appointed within 30 days of incorporation for a period of one financial year since the incorporation. So his reappointment or when fresh auditor being appointed, you can you have to appoint him at the annual general meeting for a period of 5 years. The annual general meeting is for the shareholders. So next one is in the incorporation compliances. Once the company is incorporated, that is statutory register. Okay. So there are several statutory register, but at the time of incorporation, all these things will not apply for you. Only few things are applicable. I'll explain you right now. Register of members, that is MBP1. That will be applicable because the members are the shareholders of the company. So whatever shares you issue, that has to be a register has to be maintained. So this register can be in a book format. The same the industrial and commercial print will also supply the statutory register book. But nowadays, most of the companies do it digitally. There is some Excel format. If anyone wants, I can share also, in which you can maintain all these registers instead of purchasing that book. So one challenge over here is how to authenticate, because the documents can be changed anytime. So how to authenticate that this register is a perfect document, like the final document. There was no this one changes in unknowingly. There is no changes in the register. So you maintain in the Excel, you convert into PDF, take a printout and get it signed by the directors with the seal, with the date also, and put it in the file. Or else what you can do, you can use the digital signature, or you can send these registers to the director's mail and director can just reply confirmed, in which they see the register and in the mail itself, that register will be there and the reply of the director and the timing, all those things are recorded. So register of members in MBP1, register of other securities in the sense you can have preference shares, you can have compulsory convertible debentures, compulsory convertible preference share. There is something called as OCRPS. OCRPS is optionally convertible cumulative redeemable preference shares. There are several types of securities. So for other securities other than shares, the register shall be maintained in MGT2. In the incubations, like if the incubator is investing in a compulsory convertible debenture, so this register in MGT2 has to be maintained. So register of key managerial personnel and directors. So this register has to be maintained. Whatever information what you obtain in MBP1 in disclosure of directors, what I have told you earlier, the same details you have to put it in the register of key managerial personnel and directors. Register of charges. Register of charges are you take a loan from the bank and whatever the asset, either in the name of the company or in the name of the director, you give it as a security to the banker for the loan. So that security given is called as a charge given. So charge on your asset. So in the register of charges, you have to mention what date you have filed the form, what date you have passed the board resolution, what is the loan amount you have taken, what are the assets you have given as a charge. And register of deposit. See, as a private limited company, unless and until it is a non-banking financial company or a banking company, you cannot take deposits from anyone, from the any person from the public. So company is allowed to take loan only from the directors. Directors can give loan to the company. And in case of startup companies where they have obtained DPIIT approval, the startup registration, the company can take loan from the shareholders also, but they cannot take any loan from any other person. And if the company is not a startup company, they cannot take loan from shareholders also. There are certain procedures to take loan from the shareholder. That is a lengthy procedure, but generally it is restricted to take. Loans of register, guarantees and securities. This register is if the company has given loan to any other company, and if this company has given guarantee for any loan obtained by any other company, and this company has invested in other companies where they have obtained, where this company has obtained shares, all these details has to be maintained. Register of investment not held in company's name. If the company has not invested in securities but in others' name, indirect investment, that also here it has to be maintained in the register. So all these things for the startup companies will not be applicable. The applicable will be the register of member, register of other securities, register of key managerial personnel and directors. These are the three things. And register of contract in which directors are interested. Same, any interested party where the directors are also a director in another company where you have executed the agreement with them, any contracts, those details. If you have issued sweat equity shares, there is a separate register to be maintained. Register for ESOP, employee stock option scheme. Register for share bought back. You might have seen in news saying that Wipro has issued a buyback offer. Infosys has issued a share buyback offer. So they buy back the shares and they cancel those shares, and for which they pay some money. So this is the register where you will mention the details of shares bought back. If there is a loss of share certificate and duplicate share certificate are issued, you have to maintain the register where the duplicate share certificate are issued. Register of significant beneficial owner. This is a company has a shareholding which is invested by other company. Maybe around 40% is invested in company A, 40% is invested by company B. So 40% shareholding is held by company B. Who is holding company B? Like the ultimate person's details has to be submitted to ROC. So this also will not be applicable for you right now. So I'll just give you a small brief on this format. I'll just show you a format of registers. So this is the format of register. This is allotment register. Whenever you allot, you have to mention number of allotment, date of allotment, name and address, type of securities which are allotted, equity preference, number of shares applied, amount deposited, number of shares allotted, out of subscription, how much it got allotted, distinctive numbers, total amount deposited, and share certificate number and other things. These actually might look a little bit difficult, but these are all very simple things. It doesn't come regularly for you to enter the details. It is not regular day-to-day activities. Once you have entered, the next entry will be at the time of allotment only. Till then, you don't have to enter. See, this is the register of members which I told you, MVP1. See here, folio number 1. So any number of shares which you have received, either through transfer or through allotment, will be recorded over here. So the folio number will always remain here, remain the same. It will not change over here. So this page is completely for a particular shareholder whose name you have entered over here. So his register it is. So all the shares which is allotted to him or which shares he have obtained through transfer will come over here. At the time of transfer of shares, the details will be entered over here. The balance shares will be entered over here. For example, you have 1000 shares over here. One second. I'll just fill these details and I'll just show you how. For example, that point of time I told you, A is the shareholder and you have to enter his address also. His occupation is business, his father's name, date of which entered as a member. Whenever the share is allotted to him, that is the date when he became the member. Maybe you can take today's date 23/01/2024. So allotment of number of allotment, first allotment, date of allotment 23/01/2024. So this date should match with this first date, not other date which comes below later transfer. This is the date when he became the member of the company. Number of share allotted 5,000. Distinct number 1 to 5,000. Number of date of issue of share certificate. Imagine that today itself share certificate are issued 1/2024 and number of share certificate is 1. Here transfer will not come. He is not obtaining the shares through transfer, so you don't have to enter the details over here. So the balance will come here 5,000. So you are transferring these shares. Say you are transferring 500 shares. So you will mention here number of allotment or transfer is mentioned here. So you will mention transfer TR-1. Number of date of transfer, you can mention 25th January 2024, the shares are getting transferred. Number of shares, 500 shares are getting transferred. So I can say 1 to 500 is transferring. So the balance will be 4,500 shares. So here one thing to be noted is that he is having only one share certificate. So the share certificate has to be splitted before the transfer. So I will show you the illustration for the split also. So the illustration for the split will be, you can mention of share certificate. So on the same date of transfer, you are splitting the shares. So one is 500 and one is 4,500. 1 to 500. 5,001 to 4,500. So this is the share certificate which is getting transferred. So here new share certificate number will come. For example, A and B will get 1 and 2 share certificate number. New share certificate will be 3 and 4. Okay. So here the share certificate will be 3, which is getting transferred to another person. So when you receive the share transfer, it will come here. When you receive, imagine that you received the shares from B on 30th January 2024. 1,000 shares you will receive from B. B have transferred to you. So his shares will be 5,001 to 6,000. So share certificate, again there will be a split And you can say a share certificate number will be 5. So the balance from 4,000 will reach to 5,500. So this is how you have to maintain the register of members. I can understand that you will find this little bit difficult. So once you are used to it, like if anyone has any question on this, they can approach me individually so that I can help them to get this prepared. Because of time constraint, I cannot take whole time only on this. So one is register of members, which I told you. Then other registers, which I told you is if you get debentures, for example, your incubation center, maybe ASNT is going to issue you compulsory convertible debentures. So this is the register which you have to use. All these formats will be shared to you. And this is register of directors. So director's name and his details and his interest in other companies. Details, other company's name, when he has sent a letter of interest. All these things has to be recorded over here. So directors holding shares and debentures in this company has to be detailed over here. All these things will be there, shares or at what amount, date of acquisition, the consideration paid. If he has sold, you have to mention the date of disposal and the consideration received for that disposal. So these are the main statutory registers. Other statutory registers you can ignore. In case if it comes in the future, people can approach me and I will guide you easily. Okay, the disclosure of interest, as I told you previously, in other companies has to be given in form MVP1 and DIR 8. So this is the format for MVP1 and DIR 8. ABC company given to the company, and the director is giving his name, his address, and his details has to be mentioned over here. Other company details where he is a director. His nature of interest, whether he is a director or a shareholder or a CEO or a company secretary of other company or managing director, nature of interest. And if he holds any share, you have to mention what is the percentage. And when his interest arose in that company, date of interest. And here in second para, you have to give the details in foreign companies where he has interest. You have to mention not only the company, you have to also mention the details of trust where you are trustee, partnership where you are partner, LLP or any other entity, society, association. And this is DIR, right? This is submitted to the company. Company in return submits this to auditor at the time of auditing. Almost same details you have to give here. Here majorly you have to give only the details of the company, no trust, entity and other things, company and LLP. Anyone has any question in this? This is the same document which is placed before the board for board's approval at the first annual general meeting. At the first board meeting as well as the first board meeting of every year, every financial year. So every financial year, this has to be taken on record. Sorry, I think I missed to show you the MVP1 and DIR 8. So this is the MVP1 and DIR 8, the format. This is where the director details are mentioned, other companies, nature of interest, shareholding, and date on which the interest arose. And this is the place
to give the details of foreign companies. The date when he's signing this. And this is DR8. Here are the details of the companies are given. Please note that this has to be displayed at the first board meeting of the company of all the directors, as well as it has to be taken up in each year in the first meeting. So every director has to give this at the first board, prior to the first board meeting of the company of each year, so that that can be placed in the first board meeting for the board's approval. As I told you, it is to determine the related parties. So almost most of the companies, all the startup companies or the company which is getting incorporated is automatically a small company. The definition of small company under Companies Act is like this. It should not be a public company. Okay, so public company in default will be considered as not a small company, and paid up share capital need to be equal to or below 4 crore, and the turnover need to be equal to or below 40 crore. Okay, this and will not come here. So any one of this condition is satisfied, the company will be considered as small company. Any one of the condition is breached, still it will be considered as a small company unless the other condition is also breached. So if your company's capital is 4 crore, but your turnover is 30 crore, then your company is still considered a small company only. If it crosses both, capital crosses more than 4 crore and turnover crosses more than 40 crore, then only it will not be a small company. So whatever may be the turnover and whatever may be the capital, if the company is a holding company and a subsidiary company, it will not be considered as a small company. It will automatically come out of the small company. Hope everyone knows what is a holding and subsidiary company. Anyone wants to know what is holding and subsidiary company? So I presume that everyone knows what is holding and subsidiary company. If anyone wants, let me know.
Correct me if I'm wrong. Holding is the parent company, right? Subsidiaries, which is associated to the main one. Is that correct? My understanding.
Correct. The holding company is a company where it holds shares of more than 50% of other company. So the company becomes a holding company. The other company where the whose shares are held becomes a subsidiary company. So automatically this holding and subsidiary company will come out of small company. So it doesn't come under this definition. And also to be noted, any companies which is not coming under the definition of small company has to issue the shares in demat form only. This is the new rule. So any company which is not a small company, they have to issue the shares only in demat form, dematerialized form. I mean in the electronic form. So also the company registered under Section 8 company, Section 8 of the Companies Act will not be considered as small company. Section 8 company is basically for trust activities like welfare activities. Not for profit company, it is also called as not for profit company. Any other company which is incorporated under the special act. Special act in the sense, if there is any special by the state or central government to which the company is incorporated, those company will not be considered as small company. So these are some of the exemptions to small companies, so that that small company doesn't have much difficulty in maintaining the compliances. See, whatever I have given you the brief of the compliances, for you it might look very difficult, but it is not very difficult. It is very simple because you are seeing it for the first time, and because I am explaining you in detail, so you feel that it is very big and very cumbersome. It is not very cumbersome. It is actually very simple. Just you are seeing it for the first time, so you may find it difficult. So for the small companies, at the time of audit, this cash flow is not mandatory. Preparation of cash flow statement. So auditor need not prepare a cash flow statement at the time of auditing. So every company has to hold minimum four board meetings, but small company can hold 2 board meetings in each half of the year. Every 6 months, they can hold 1 board meeting. And there is some reporting under CARO 2020 that is given by the auditor at the time of auditing, that is also not applicable. And annual return has to be submitted to ROC every year, register of companies. And that annual return need not be certified by any professional, whether it's CA or CS. So without certification of CA or CS, it can be filed. So there is something called as internal financial control for the companies to control the activities of financial transaction of the company for the check and balances. That reporting for the auditor is not mandatory for the small companies. And the annual return is filed in a simpler form, that is MGT 7A instead of 7, which is slightly complicated. And lesser penalties and fines under Companies Act for small companies compared to larger companies. Any questions? So next, I'll take up the topic of board meetings. So as I said, small companies should have minimum 2 board meetings in a year. So that should be fall in each half year. For example, the financial year is from April to March. So April to September, between that period, 1 board meeting and another board meeting between October to March. And the gap of this board meeting should not come within 90 days. It should have at least a gap of 90 days, more than 90 days. If any meeting is held within the gap of 90 days, then you have to hold the third board meeting. In case of other companies, other than small company, it is 4 board meetings, and gap of 2 board meetings should not be more than 20 days. Here, the gap should not be more than 20 days. It should be within 20 days. There, it should be more than 90 days in case of small companies. And in 4 board meetings, it should be held in each quarter for other companies other than small companies. As I told you, 7 days notice has to be given for each board meeting. And if it is a shorter notice, you can mention in the notice saying that meeting are held in shorter notice. Meeting to be recorded if it is held in video conferencing, and it should be maintained in company's data. Documents like attendance sheet, notice, agenda, and the minutes needs to be maintained. I'll just give you an illustration of how the attendance sheet and other things looks. Notice I have already shown you. So this is attendance sheet. This is how it looks. Date of the meeting, time, venue. This is there are very much a complicated format of attendance sheet. I'm giving you a simple format. So these are the name of the directors and their signature. And any of this person will be appointed as a chairman at the meeting, and the chairman has to sign here also. And any person having attending the meeting through video conference, for example, the first person will attend through video conference. So here it will be mentioned attended through conferencing. And here the chairman only has to sign. As Ashokan is attending the meeting physically, so he will be the chairman. So he will sign here in this area, in this place, and here also he will confirm that he has attended through video conference. So I will show you the draft of the minutes also. So this is how the minutes looks. So the company name, address, SIN number, the minutes of the first meeting of the board of directors. The serial number is very important. Every meeting has to be serially numbered from the first meeting. First meeting of the board of directors of the company held at the registered office of the company at this place, the date of the meeting, the time of the meeting, when the meeting started, and the directors present. And if any other person is attending the meeting, for example, invitee, you have to mention here. Maybe some Mr. A, he may be the CFO of the company. Bigger companies where there is a whole-time company secretary. So company secretary will also attend the meeting. But the voting rights will be there only with the directors, not with the invitees in the board meeting. So first thing is chairman of the meeting. So chairman will be appointed, and the starting time of the meeting is mentioned. We have to see whether the quorum is present, that the minimum number of person to be present is 1/3 of the total directors or 2, whichever is higher. Leave of absence. If any person is absent, you have to mention this person is not able to attend the meeting as he expressed his unwillingness to be present due to certain circumstances. That has to be mentioned over here. Mode of attendance, physical or through video conferencing, you have to mention over here. Then all the resolution, as I told you, will be passed. Whatever is discussed in the meeting, that has to be mentioned over here. And every discussion is through passing a resolution. So for example, here statutory auditor is appointed. So this auditor is appointed, and you have to file Form ADT 1. So this, out of the whole minutes, only this part is taken out separately and given as extract. So that is what is called as extract. This is the difference between minutes and extract. So hope you are clear with the minutes also. If anyone having any doubt in the minutes, you can mention, can also ask. So here we have taken on record of MBP 1 and DAR 8. That resolution is passed in the first meeting. And date of signing is mentioned over here. That is the next board meeting date. Date of entry is mentioned over here. The minutes should be ready within 30 days from the date of the meeting. So the date of entry should be within 30 days. The date of signing will be the date of next board meeting and the place of signing. And the end date of the meeting, where the end time of the meeting, where the meeting has been concluded, also needs to be mentioned over here. So the general meeting. Next one is annual general meeting. So this is general meeting is always held for the shareholders. So it is a shareholders meeting, also called as shareholders meeting. So annual general meeting is called as annual general meeting because it is held once in a year. So it is held annually. So that is why it is called as annual general meeting. To adopt, generally annual general meeting is held to adopt the auditor financial at the annual general meeting, appoint auditor, appoint new director, or pay dividend. This is the reason why annual general meeting is held, where you present your financials of the yearly result to the shareholders of the company. And whatever the shareholders has any question in the annual general meeting, they can post the question. and the directors or the CFO or any person authorized has to answer the shareholders. So other than these things, any other things are also taken. For example, you want to issue a shares through private placement offer, that also can be taken. But annual general meeting, this is mandatory. Any other point where shareholders approval is required, that also is generally taken in the annual general meeting. Notice for the shareholders has to be 21 clear days. Clear days in the sense, date of the notice, date of sending the notice, and the date of AGM needs to be excluded in counting of 21 days. So if you include that, it will be 23 days. Documents like here also documents like attendance sheet of the shareholder, notice of the meeting, minutes of the annual general meeting has to be maintained. First annual general meeting due date is 31st December. Okay. And after that, on the second year onwards, the due date for holding annual general meeting is 30th September. Also, please note that the gap between two annual general meetings cannot be more than 15 months. It should be within 15 months. So as annual general meeting is held once in a year, if you want to take some approval from the shareholder for which you have to take, for which you have to hold one more meeting for the shareholder, that is between two annual general meeting, that is called as extraordinary general meeting. Some extraordinary situation where you have to take shareholders approval, maybe some investor is coming, you are going to issue fresh shares to the new investors, you have to increase the capital, you are changing the object clause of your company. In that case, you have to obtain the shareholders approval. If you are hold it, this situation comes at the time of holding annual general meeting, so you can take it at the annual general meeting only. But it comes between two annual general meeting, then you have to call for additional meeting called as extraordinary general meeting, and these resolutions has to be passed. So yearly ROC filing, annual filing. So there will be generally 3 documents to be filed. One is AOC 4, one is MGT 7. As your company is small company, for you MGT 7A is applicable, and ADT 1. ADT 1 comes in once in 5 years, unless and until your auditor resigns, or you remove auditor and appoint a fresh auditor. So most of the time, ADT 1 will be for once in 5 years. So AOC 4, what you will enter all the details of the whatever the things they ask in the AOC 4 form, and you will attach notice of the annual general meeting, director's report, shorter notice if the notice is held 21 days. Please note that below 21 days also you can send a notice, but you have to obtain 95% shareholders approval, written approval, saying that we are okay to hold the meeting at shorter notice, and audited financials. So all these documents, notice of the annual general meeting, director's report, shorter notice, and audited financials shall be attached in form AOC 4, and you have to fill the AOC 4 and submit it to ROC. Generally, this work will be done by your consultant, whoever is handling, whether it is a chartered accountant or the company secretary. Okay. So you yourself also can do this, but it is highly risky to do without the consultant's help. It may create several mistakes. So MGT 7A, list of shareholders and list of directors as on March, at the end of the year, what are the shareholding list, what are the directors list has to be attached and has to be submitted. And as I told you, ADT 1 for the 5 years, proposal letter, confirmation letter, and resolution extract of annual general meeting. So now allotment of shares or other securities. This is slight important for you, mainly because your company is a startup company, and there is future potential investment from the incubator, or maybe from the private investors from the outsider, or the angel investors. So whether it may be shares which you are going to give, or other securities like debentures, compulsory convertible debentures, or compulsory convertible preference shares, you have to follow certain procedure, and this is very, very important. So if you are issuing shares, there are several ways. So private placement or preferential allotment. This is for the new people who is coming as a shareholder. Right issue is for the existing shareholders. So existing shareholders only you are going to issue additional shares as per the proportion what they are holding. So at that point of time, right issue of shares is done. So this is not very complicated procedure. This is very easy procedure. Bonus issue, where you have you are issuing bonus shares. For example, a person holding 1 share, you are going to issue 5 additional shares to that person. In that case, the bonus shares will be given, where you are not going to take any money. In the case of private placement and rights issue, you are going to take the money from the shareholders. In the case of bonus share, you are not going to take any money. You are going to issue the shares in ratio, maybe 1:5. For every 1 shareholder, you issue additional 5 shares. And for that purpose, reserve of the capital is used. So whatever money is mentioned in the reserve will be capitalized as shareholders' money. Employee stock option scheme. So you issue shares to your employees through a scheme called as employee stock option. So this employee stock option is given. Sweat equity shares. For example, any employee of your company has done something to you. For example, invented some IP, but you don't have money to pay him. So instead of that, whatever the worth of money his IP is, to equivalent to that, you issue a shares. So that is called as sweat equity shares. You issue shares in the free of cost for some services or some product what has been contributed by your employees. So here the main thing you have to notice the private placement allotment and the preferential allotment, where your investor or the incubator invests some money and they say that you have to allot as a compulsory convertible debentures, 2% compulsory convertible debentures or equity shares. So as they are the new person entering into your company as a shareholder, it is a lengthy procedure, but the main thing which you have to keep it in your mind so that your consultant also doesn't do mistake. Most of the consultant also does the mistakes in this. So you have to open a separate bank account. You have to maintain a separate bank account where the fund has to come. You should not use the regular bank account of the company, operational account. You have to use a designated bank account, separate bank account, where the funds will come as the investment. So offer letter, there is an offer letter for the allotment that has to be issued only after filing form MGT 14. I know this is complicated. This doesn't make any sense for you because you have not seen all these forms. So, but just keep it in your mind. Some of these points I will share this presentation also, so that at the time when your consultant is doing the allotment procedure, see to it that these procedures are followed, or at least you can ask your consultant whether these things are done. So the offer letter has to be issued only after filing form MGT 14 to ROC. Funds has to be, whatever the funds comes to the designated bank for the allotment of shares, these funds have to be utilized only and only once you allot the shares, file form PAS 3 as a return of allotment, then only you can utilize the fund, only after allotment of shares and filing of PAS 3 to ROC. So till that you cannot utilize the fund, it has to remain in the designated. You cannot do even FD also. Most of the time this point is violated, this law is violated actually. So please see to it that this is not done. So documents to be maintained, that PAS 4, that is offer letter, what I told you over here, that will be in the PAS 3 format, 4 format. And details of shareholders for whom the shares are allotted is in 5. Notice of EGM. You have to hold extraordinary general meeting here, shareholders meeting, for taking the approval for issue of shares in private placement and preferential allotment. The notice issued to the shareholders to attend the meeting, that has to be maintained. Certified copies of EGM extract, the resolution extract has to be maintained. List of allottee and the board resolutions, where you pass a resolution to allot the shares once the fund comes. So before you issue the offer letter, you have to hold the EGM and approve the offer letter at the EGM. So it has a lengthy procedure and a cumbersome procedure also. And your consultant generally knows all these things, how it is done. So these points, if you have in your mind, you can check whether your consultant at the time of allotting is doing a correct job. These are the points where they go wrong. That is why I have mentioned only these points. Other points, even if I say, you will not be able to understand it, because this is understandable only to regular people who do this work regularly. Other compliances, like every year, all the directors DIN has to be active. So they have to file their KYC with ROC. The due date for filing the KYC is 30th September. Even a single day delay will cost you 5,000 per director. So you have to pay 5,000 fee after 30th September. So make sure that your director KYC is filed within 30th September. The time period is from April 1st to 30th September. Within these days, you have to file director KYC. So whenever the director gives loan to the company for all these startups, generally what happens, the director and promoter itself put their money in the company. So in the company's books, it will be mentioned as loan from director. So every director has to give a declaration to the company saying that. I'll just show you the draft declaration. See, this is the declaration which has to be given, saying, I, son of this, residing here in the capacity as a director of this company, do hereby solemnly declare that I have lent this many rupees, like in figures and words, as unsecured loan at the interest rate of that, may with interest or without interest, anything it can be, to the company, and the said amount of money out of the said amount of money, or out of the said amount of money or rupees, my own funds, and not being given out of the funds acquired by borrowing. So the fund should be your own saving, loan obtained from other people or deposit taken from other people. So this declaration has to be obtained from the director each time when you are taking loan from him. So are you clear about filing a declaration of directors? Hello?
Yes, sir, you're audible.
Are you clear about this declaration of directors? So what was this Zoom disconnected when I described about this?
No, sir. It was connected.
Yeah, okay.
Yes.
So this is the declaration of directors. So this is all director KYC is mandatory. Declaration of director, situation based whenever the director gives the loan to the company. Filing of DPT3, if the loan is taken from the director or bank, all these things has to be reported yearly in the form DPT3, and the due date is 30th June for the same. And if next form is form MSME 1, if there is a return, if any payment is pending from your side to your vendors, and vendors come in the category of small and micro entities as per Udyam registration, and if your amount is pending for more than 45 days, that has to be reported every half year in the form MSME. So if you don't keep any payment pending, this return is not applicable. But if you keep the payment pending and that that vendor comes under small and micro entities. Maybe it may be a proprietorship also, but they have registered under Udyam and it comes under micro and small entities. Then you have to file this return and you have to mention what is the reason that you have not paid within 45 days to them. And it has to be filed in every half year. For September, it has to be filed within 30 days by October. And for March, it has to be filed within 30 days by 30th April. So transfer and transmission of shares, that has to be executed in the format SH4. That SH4 is online. It is available for you. You can download that SH4 format. In Word format also it is available. You can download and you can execute. All the details are simple. Distinctive number, share certificate number, name of the transferor, witness, transferee's name, PAN number, email ID, all those details. Appointment of auditor for a period of 5 years. So as I told you in AGM, auditor will be appointed for a period of 5 years. So after the expiry of 5 years, you have to take it up again at the AGM after the period of 5 years, maybe a 6th AGM, where you will reappoint the same auditor or you are going to take up the new auditor. So these are the basic things. Other complicated things I have not taken up. I think this will be more than enough for the startup companies. Other complicated things are all situation based, where your consultants will help you. Anything, any doubt anyone is having can approach me through this number. I am not going to charge you for asking advice or helping in any way. So take down this number if you have any doubt or clarification at the any time of your procedure of your company, whether it is allotment and other things or anything, filing of director KYC or something like that. You can call me and ask me. I will be happy to help you. And this presentation and certain formats, whichever I have prepared, I'll share it. You can see those formats. That's it from my side. Thank you. Anyone having any doubt can ask.
Yes. Anyone having any doubts, please ask.
Sir, this is Ram Kumar. Sir, initially there is the founders share amount and then form the company, right? You said exact amount should be transferred.
Yeah.
How do you decide the amount, sir?
At the time of incorporation in MOA, it is mentioned, no? What is the number of shares and what is the amount? That amount itself.
So any capital further infusion is separate. This is only as a shareholder, isn't
this is only for the filing commencement of business. Future investment is separate. That doesn't come under filing commencement of business. Commencement of business is filed only once at the incorporation, after incorporation within 180 days. After that, any time in the future, no commencement of business is filed. That is only return on allotment for the fresh issue.
Now, my question is, initially somebody invested 2 lakh, another fellow invested 3 lakhs, so total 5 lakhs.
Sir, that is different, sir. That is after incorporation, future investment it is.
No, first time, first time I'm asking.
At the time of incorporation, if you see in the MOA, Memorandum of Association, last page if you go, you can see there, like what is the name of the subscribers and what is the amount and what is the shares they are investing. So that is the amount you have to deposit through that person only, and the commencement of business is filed. You are not clear?
Okay. Yes, sir, I got it.
If you want, I will open one MOA and show you.
No, my question is simple. Like I used to see in the company websites and all, they will say this many shares worth of this person, this many shares worth of. So they give some value. The company is very big, but they initially show totally 5 lakh, 10 lakh only, the total value in the beginning. I was always wondering how they decide that initial shareholding value or, that company. That's what my question, not the procedurality, but the
value is determined by the valuer. Okay, general value is determined by the valuer, but the face value will be as per your MOA for a nominal value. That is maybe 10 rupees or 1 rupee or 5 rupees, whichever you mention in your MOA.
Okay, sir. So it is a kind of
additional
an
value. For example, you grow your business, your value of share will not remain 10. It may
correct.
become 50 or it may become 500 or it may become 10,000 also per share. In
Correct.
that, face value is 10 rupees. Remaining amount is the value which you obtain, that is called as premium.
Hmm.
Okay.
So it is
See,
just for the shareholding purpose, isn't it? Just to show who holds how much. That's all,
yeah,
isn't it?
yeah. Sir, I will give you one example. Wait for a second. Sir, if you see here, this is a moneycontrol.com. This company is called as AJ Greenpack Limited. If you see the market rate, today's market rate is 777 rupees. But the face value of this share is not 771, it is 2 rupees.
Yeah, that I understand, sir. I understand.
Okay.
Hmm.
So now if they want to issue fresh shares to the some selected shareholders, they will issue at this price. So remaining amount like 775 rupees is premium, only 2 rupees is face value.
I know.
So that is what it is. And commencement of business is filed only once at the beginning. That is for the money deposited, which is mentioned in at the time of incorporation. At the time of incorporation, where subscription amount is mentioned in MOI.
Hmm.
That's it. And future allotment, whatever comes, it is allotted by valuing your shares by the registered valuer. And you value those shares and issue the share certificate shares. In that case, commencement of business will not come. It is only allotment of shares. For that, a return called as PAS 3 is filed, where you submit with the list of allottee and board resolution.
Okay. Thank you.
Thanks. Anything anyone can ask?
Hello, Chetan sir.
Yes, Dr. Santosh.
Yeah, just a few words, sir, for Chetan sir. He has elaborated very nicely with all these concepts. And sir, if at all it is regarding LLP and some other sort of business entity, you'll be giving the input, no, sir? Some other day.
Yeah,
we
I will give you
directly.
input on that also. You can call me anytime.
Yes, sir. Yes,
so,
sir. Yes, sir.
See, generally what happens in LLP, I'll give some brief over here so that other people also can understand. In case of LLP, there will be only 2 return to be filed in a year.
Correct.
That
sir,
is
correct.
annual return and financials.
Yes, sir. Yes.
And the turnover, if it increases beyond 40 lakh only auditing is required. Others auditing is not mandatory for LLP.
Correct, sir.
And one more new return is going to come, that is significant beneficial owner, when a other company is a partner in the LLP. Other company or other entity is a partner in the LLP. So ultimate beneficial owner behind that company has to be declared. That return will come in the future. Maybe in a few months it is going to come. So
Yes,
see, I will tell you when the LLP and company will come. Generally, who start a family business, they will go for LLP.
correct.
And whose business is limited to a certain extent,
Correct.
has certain limit, they will go for LLP. But whose potential is very huge, and they are 100% sure that we are going to get investment easily because our product is very, very good.
Correct.
Then they go for a company.
Okay.
Because other than incubator, any other investor who is coming from outside, they always expect it to be a company. They will not invest in LLP at all.
Okay.
Very rare. Maybe out of 100%, maybe 5% or 10% are ready to invest in LLP.
Yes.
But nothing to worry about it. Even if it is LLP, anytime they are ready to invest, you can convert the LLP into company.
Yes, sir. We had some online cutting with that LLP earlier. We have not registered, but yeah, that's right. Thanks
And
a
one
lot.
more
Thanks
thing
a lot.
is,
Sir.
Generally, depending upon the situation, I suggest my client to go for LLP or a company. So I ask them, what will be your turnover for 5 years? What will be your future perspective? If their business looks promising, and if I feel that they are going to progress, then I will suggest them to open a company, and where I feel this has to take some testing and this has to be tried, then only we'll come to know. Then I will
Correct.
tell them to go for LLP.
Yes, sir. Yes, yes. Understood, sir. Thanks a lot.
I know
Thanks a lot for all
LLP
other.
is easy, company is difficult. I understand
Yes.
that.
Yes, sir.
But generally, what happens is you go for a company secretary somewhere outside, a new company secretary, they will always suggest you to open a company because they will see their income.
Correct.
No, I am not blaming everyone.
Yes, sir. Yes, understood.
I don't want to unnecessarily blame him without any basis, but there is
Correct.
a possibility. There is a possibility. This way.
Correct. 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 Yes, sir. Yes. Thanks a lot. Thanks a lot. Yes.
Sir, another question. In startups, no, I will start with one idea, one product, and one partner. Later, associated area, but it can be another project with one more different concept. So how does it company absorbs that kind of addition, or is just issuing shares to them, or how is it?
No, sir, come again. Can you repeat it?
Sir, originally two people form it with one product in mind, which is based on a particular innovation. Later, the same company involves in many research products. Okay, they come with one more product with another partner or another collaborator, but the company is same. But the new collaborator is not inside the company. Now, how to add it, or how to, without affecting the.
You can appoint him as a director and you can allot him as shares.
That will be additional shares, isn't it?
Yeah, correct. Additional shares, or you can transfer your shares also. I told you I have given you the instruction, showed you that illustration. A and B transfer shares to C.
So
That
the
also can
original
be done.
numbers will remain same.
The original, if you allot fresh shares, original number will remain same. If you transfer there will be some changes in the shareholding pattern.
Correct. Okay. Thank you, sir. Thank you.
So if any other questions?
Also, one point I want to express here. See that for your compliances for your company or in the LLP, 100% it is going to cost from your pocket. That is for sure. Okay. So always make sure that the person who is charging is reasonable, as well as he can do a good job. Just don't search for a person who is doing for a very less price. Very less price means almost 90% of the cases, it is like documents are not maintained properly, or everything is like not complied. That you will come to know at the time of doing a due diligence. At that point of time, if compliance are not maintained properly, investor is not going to invest. So see to it that the person who is going to do the compliance work does a proper job and does at a very reasonable rate, not at a high price. Don't go for very low price, then there is something wrong. That's it.
Okay. So you are helping for our for startups also for this incorporation?
No, startups who come to me from incubation, I help them. Sometimes what happens, they have their own consultant, they will go to them.
Okay. So this company secretary and auditor are not same, isn't it?
No, it is not same.
Okay. But many times auditors become company secretary, is it?
No, auditor is a CA. He looks into your auditing at the year end. Or sometimes certificates has to be issued. No, some certifications has to be done from the auditor where you have to give amount utilized certificate, utilization certificate. All those cases, auditor will be there. Company secretary is generally for the compliance, for holding, maintaining the documents like minutes and other things, filing ROC returns, or any notice is received from ROC, to reply that notice, all the ROC related works and compliance related works for maintaining the documents, and any other advice where you have certain doubts, you want to take some advice with related to issue of shares. All those things will be helped by company secretary. And allotment procedure and other things are also done by company secretary.
So this PowerPoint, can you share it, sir, if it is okay?
Yeah, I will share it. And one more thing, I just wanted to share you one more thing. Just a second. So see, this is in MC website, Ministry of Corporate website. See here you can see in past few days, like orders passed by the register of companies from several register of companies. Okay, like for the not following the rules and regulations of Companies Act. You can see Uttarakhand ROC has levied penalty on certain things. You can get this order also. You can download it and you can find out what order they have passed and why they have passed. What is the wrong thing they have done. So this compliance is very important. So make sure that you follow the rules and regulations. Actually, when I explain, it might find it you might have found it very difficult, but it is not like that. Actually, it is for the person who is doing this day to day. It is okay. He can do it. Not that difficult. So any person interested can go to this website, MCA website, and data and reports, RD and ROC adjudication orders. And you can see our Karnataka ROC also, what and all orders they have passed. So Bangalore, last order they have passed is on 18th December 2023. I think they are not updated. I think it may come anytime. Any orders passed after 18th.
So these startups, what is the value above which we have to undergo all these things, or any company, any startup with even no transaction has to do all these things?
Yeah, they have to do it mandatory.
Because we are all academicians involving into research and then into
Yeah,
you
sir.
know, startups.
Sir, in this case, see, I will tell you. I gave you all the things, but all the things will not come to you. See, MSME, when you are not done, the payment only will come, no? MSME return. This MSME return, you don't have to file. And DPT3 return also, only when there is a loan from the directors or other people, you have to file. Or else, only thing what you have to do is, you have to prepare the documents of 2 board meetings, 1 annual general meeting, and once in a year, you have to do the ROC filing and IT return filing. That's it. Nothing more you have to do. If there is no operations in the company, only these things. Paper documents you have to maintain.
Okay. And GST is a must, is it? GST number.
GST is not mandatory. GST is mandatory for the services if your turnover increases more than 20 lakh. For the manufacturer, if your turnover increases 40 lakh.
Okay.
And for e-commerce business, GST is mandatory from the beginning itself. And one more thing. See, for example, you do innovation and research and you have to purchase some machinery, big machinery, where you spend some 50 lakh, 40 lakh and all. In that case, maybe even 10 lakh also. In that case, it is better to obtain a GST number, because when you purchase any capital product, maybe machinery or something, they will charge you GST also. So the GST amount in the case of bigger amount, the amount will be huge. Maybe 1 lakh or 2 lakh will be the GST amount itself. So if you have a GST number, what will happen? You will update that invoice in your GST. So that 1 lakh or 2 lakh GST, what you have paid, will be credited to your GST account, and that credit can be utilized for your future sales. You sell certain product and you get income where you charge GST also, that will be set off against this 2 lakh. So that amount can be saved. So in that case also GST, it becomes required. It is required to obtain, so that the 2 lakh credit can be obtained.
Thank you, sir. This GST is state specific, sir?
Yeah, state specific.
If you have one in other state, you have to close that and open it here, is it?
Not closing. You can obtain all the states GST also. But it depends upon branch. you have branch in other state, you have to obtain GST for that state also.
Oh, so you can have multiple states. Okay.
Yeah, yeah. Only it is
Now-
required. Only it is required you have to obtain. You need not obtain unnecessarily in all the states. And the compliance burden will increase. And all these compliances, what I have showed you also will reduce in the future when the time comes. Actually, before this, it had much more things to do. Now they have the government is seeing that ease of business. So drastically almost 50% has come down. Another 10 to 20% will come down.
Sir, GST is required for all the online businesses, sir. As you said, this is
E-commerce business is required. If you are selling goods through online, it is mandatory. Just to check with your chartered accountant also once.
okay. So, in any form, if it is online, GST is required.
Yeah, yeah. As far as I know, it is required. But you have one consultation with your auditor also, CA also.
Yes, sir.
Yes, sir. I think the session is extended a bit today. So if no other questions, could we conclude, sir?
Yeah.
Yes. Thank you, sir, for your sharing your knowledge. I think it was very informative session, and I think it was a bit difficult for them to understand, but I'm sure you will be available to help them out in these
Yeah.
procedures. So I thank you again, sir, for taking out your time and sharing your knowledge with our startups. And thank you, participants, for joining today's session. Thank you,
So
sir.
anyone can call me anytime.
Yes.
If you have any doubt, please note that.
Yes,
Thank you,
definitely,
Mr.
sir.
Chetan. I am
Thank you.
Ram Kumar. Very kind of you. Very patient and very passionate in explaining. Thank you. God bless
Thank
you,
you,
sir.
sir.
Thank you, sir. Thank you, sir.
Thank you, Dr. Ram.
Bye. Bye. Thank you, sir.
Bye-bye.
Thank you.